There's 3 mistakes you should never make in court. Believe it or not, rolling your eyes, just rolling your eyes, could make a judge rule against you in a court of law. Most people don't understand that, but the way you behave can make you lose credibility long before the judge is ever ruling, or the jury. And it's not because the law is against them, it's because of how they react under pressure. The courtroom is not a casual conversation or a performance for entertainment. It's a controlled environment where every reaction is observed, interpreted, and weighed. Judges notice tone, timing, posture, and restraint long before they weigh emotion or explanation or even the law. In this video, I want to go through things you should never do in a courtroom, not from theory or television, but from experience, but from where our courts actually work when real outcomes are on the line. Why do I know this? Well, I actually had the opportunity to clerk for one of the most famous district court judges ever, Jack Weinstein, in the Eastern District of New York. As clerks, we get to sit in the courtroom with the judge and the parties. We see everything. But what we get to do that no one else does is we go behind closed doors. So when the parties all go and everything is over, we go into the judge's chamber. And that's where we see what really happened. We see how the judge interpreted something. We talk about it. We discuss how people were acting and reacting. And then the judge comes to a decision on how he's going to rule on any particular matter. And he says, okay, now your job as clerks is to go and justify the decision. And we have a lot of power to do that. We have cases, we have statutes, but we also have equity, which means the judge can actually disregard case law or even a statute if equity demands it. So the power of a judge is really strong and not something most people understand. And when you get the judge against you, you have very little hope of winning, even when the facts are completely in your favor. So understanding what to do and what not to do in a courtroom is essential. So number 1, mind your reactions. You are being observed. Every single little thing is being observed by the judge, and if there's a jury, by the jury. Believe me, they have nothing to do. They're sitting there. All they have to do is watch you. So they see everything. There's a famous old case where one of the lawyers was smoking a cigar back in the day when you could smoke a cigar in a courtroom, and he was not tapping out the ash, and the ash just kept getting longer and longer. Nobody was paying attention to the other lawyer and the summation of the case he was making. They could not rip their attention from this cigar ash, which was just growing longer and longer and longer. And in the end, of course, they didn't hear a word that the other side had said, and that lawyer with the cigar, he won the case. Well, what he had done is he had taken a paper clip, straightened it out, and put it in the cigar to hold up the ash. But it was perfect. He designed something that would draw the attention away from the jury. And so believe me, that doesn't happen anymore. So while you can't smoke cigarettes or cigars in the courtroom anymore, so while you no longer see attorneys smoking cigars in the courtroom, what you do see is every action and reaction being monitored, weighed, and judged. Small physical reactions like rolling your eyes or sighing, those are really powerful because they are telling the jury or the judge very directly how you're feeling. And they're going to interpret that. And most likely, because you're reacting and you're not holding yourself, they're going to interpret it against you. It also undermines the credibility of the courtroom that you're in and the judge. So if you're sitting there sighing and rolling your eyes, you're not taking this seriously. The judge does not appreciate that. The jury does not appreciate that. They're taking their time. They're not going to their work. They're taking it seriously. And if you're not, believe me, that is not going to help your case. Judges are trained to notice everything, whether actual training or by years of experience. Believe me, even when it looks like they're not paying attention, they might be writing something or apparently focusing on something else. The reality is they're noticing everything. And what they notice most is emotional reaction. When you're getting emotional, it is something that is not seen as credible. It is inauthentic, especially when the emotion seems contrived. So we saw this, or we see this in politics, when the parties are having a debate and one side just rolls their eyes or does something like, oh, I can't believe that. We interpret that as just being inauthentic. And inauthenticity is the key problem. Everyone loves authentic communication. Everyone loves authenticity. We all want it. We all crave it. And if you're trying to make a show or play a game, it will be weighed against you every single time. Whispering to your lawyer is another thing. It may look kind of cool on TV. I've got something important to say. The reality is it can be interpreted in so many different ways, most of which are going to be seen as not positive to you. So be extremely careful before you just start doing things and drawing attention. Unless that's your purpose and you know what you're doing and you're doing that on purpose to draw attention away from something else. But remember, that sword always cuts both ways. So when in doubt, I wouldn't do anything. I would stay clean without reaction no matter what the other side says. Silence, stillness, equilibrium, that's powerful. That tells the other side that you're not triggered by what's being said, that you're clear and you're clean about how you feel about something. If you're triggered, it's noticed. Everything, your body posture, your breathing, your facial expressions. So your job is to be very clean in your energy and keep focus and make it so that when the judge or the jury looks at you, what they feel is something that is authentic and clean. That's going to speak a lot louder than the words that are coming out of anybody's mouth in that courtroom. We've all heard that 85% of communication is nonverbal. Well, I'm here to tell you in a courtroom, it is absolutely true. 85% of what's really going on in that courtroom is not the words that are being spoken. If it were the words that were being spoken, it would be easy. You just get the best words and you win. It's not the best words that win. It's not even the best law or the best cases or the best statute or the best research. It's the cleanest energy. It's you holding yourself together, and that goes for your lawyer too. You want a lawyer that is clean, that can hold themselves, that doesn't react as well, because your lawyer represents you. And so it's not just you, it's your lawyer, it's the way that the entire process is respected. If your lawyer disrespects the other side, is disrespectful and disregarding, making them feel like they're not valuable, you don't have any idea whether the jury is connecting with the person on the witness stand or with the attorney. You're taking a huge risk by doing that. And the judge is most likely not going to appreciate it. All of this, all of your behavior, your expressions, your energy, your tone, your posture, all creates the environment in which a decision is actually made. And that decision is made by the judge and or jury unconsciously, most likely. They have made that decision long before you ever even reach the finality of the testimony and all of the closing arguments. The decision is a felt thing. It's not a rational thing. We all think that rationality rules the day. It's funny. In economics, they taught you the rational theory of economics. If this happens, then this happens. And if this happens, and this happens, and everyone's always going to act in their best interest. And that just completely failed. Why? Because people don't act in rational ways that are always in their best interest. They react in emotional ways, and they make decisions based on emotion. And so a judge and a jury are going to make their decision based on how they feel about the parties, not by just the law and the facts. They will consider it all. But at the end of the day, it's how they feel that's really going to matter. And this impression is made almost immediately. Within the first 2 or 3 minutes or 5 minutes or 15 minutes. It's not after 2 days of trial and testimony. That's going to reinforce what they felt at first. But if the feeling at first is one way, it's going to be very hard to overcome it the other way, particularly if it's negative. So if the judge has a negative impression of you immediately, it's going to take a mountain to get him back into a positive impression of you. If he has a positive impression of you, you are already just don't have to mess it up at that point. You just need to hold the line. So that first impression is the most important. And we all know this is true, whether it's dating or a business partner or even a client. You know immediately in that first impression, is this going to be a good relationship? It's going to be a difficult relationship. Your job when you're coming into a courtroom is make sure that that first impression is clean and it's clear and it's honest and authentic. That's what's going to matter more than the facts and the case and the law. So by now you've probably started to figure out that it's not about being right. It's about being liked and believed and seen as the authentic party. That's your real job.
It's about how pressure is being interpreted and how credibility is being weighed and how small mistakes can compound when the stakes are high. And in reality, that dynamic happens long before you even get to the courtroom. All of this matters. Most damage to your position happens before a judge ever even knows your name, particularly if your assets are exposed or your structure has already failed. In fact, if you want to see how exposed you already are, take this 7-minute exposure test. It's free. It's not legal advice. It's just to help you understand what's already exposed in your life from an asset protection standpoint. It walks through your assets and shows you what could be reachable in a lawsuit when it goes from complaint to collection. It's not a sales call and it's not legal advice. It's just a way for you to assess your own risk and your own exposure. The link is in the description below. Let's go to number 2. Do not interrupt. This is a biggie, which is why it gets its own section in what not to do in a courtroom. You already know this is true. When someone interrupts you, you already feel their credibility going down. Interrupting people is not only rude and disrespectful, but it's telling them that you're not even listening to them. So interrupting is probably the least helpful thing you can do when you're sitting in a courtroom and everybody is scrutinizing absolutely everything that you're doing. And if you make it a habit and this becomes your thing, interrupting, you're already going to be seen as the bad guy. And that is not going to help your case. Some people think this might be an advantage. They always have an answer for everything. But the reality is it's not an advantage. It just makes you look weak and insecure. It also shows lack of discipline. I mean, talking over a judge or the other side's attorney or a witness, that just shows that you don't have the discipline and the confidence in what you're going to hear. So you're trying to cut it off. You're trying to control the situation. You're trying to make it your courtroom and your game. And the problem with that is that it's not. It's the judge's courtroom and ultimately the judge's game. If you get on the wrong side of that judge, God help you. You're in for a ride. Patience, calmness, on the other hand, is seen as strength. You're not weak to hear somebody out. You are going to have your chance to speak. You don't need to interrupt anybody. You don't need to speak over them or disrespect them. When it's your time, all that calmness that they saw when you were listening to the other side, if you can then present that in what you're saying, your words will have so much more power. And again, this applies to you, but also your attorney. It's very important that your attorney really understands this. And that's why choosing the right attorney is critical, particularly for something that is so serious and so high stakes as protecting your assets. If you do have to clarify something, if something is really going off the rails and it's getting down the rabbit hole, it's not you that should be doing it. It is your attorney. And in that case, your attorney needs to step up, stop something from going the wrong direction, get off the rails. If you have to, your attorney can request to approach the bench, have a sidebar, recess for a few minutes. The attorney has plenty of options to make sure, which again is why it's so important which attorney you've chosen. Someone who understands the system, somebody who can play this and is not unfamiliar, somebody who understands A to Z, not just A, B, C, but then when it gets to Z, they're out. It's critical, and leave those jobs to that attorney. If you appear unwilling to wait and you just can't hold yourself, you are risking everything, because your credibility and your authenticity can be lost in a minute. Often the best thing to do is not be the visible opponent. Let the other side make all these mistakes. Let the other side get on the wrong side of the judge and on the wrong side of the jury, because most people are going to get it wrong. They're not going to get this kind of coaching. They're not going to be clear. They're going to end up making the mistakes. So it's yours to lose. And again, if you make a first impression that's strong, all you have to do is not mess it up and allow the process to unfold. There is a process to this. It will take time. You can't get your whole story out in the first 5 minutes. You want to let the system take its course, but you want to be in your own space, grounded as that's happening, because that's all you can control. You don't control the system. You don't control the courtroom. You don't control the judge. You don't control the juries. You can't even control your own attorney, and definitely not the other side, but you can control your own groundedness. You can give that clarity and that sense of surety and security, even if you don't feel it, which is why it's so important that you do feel it, which is why something like asset protection is so critical. If you knew that regardless of how the case turns out, you're actually not going to lose any money, how much easier is it for you to be calm in the process? One, before it ever gets to trial, but definitely two, if it ever gets to trial. That's the power. It's not just telling the other side to go pound sand, I'm protected. It's about giving you peace of mind. That is the whole point of asset protection. Peace of mind for you, so that you can stay calm and you can stay grounded at any stage in the process, no matter what's happening. And number three, understanding the power structure. And this can be the hardest for some people because they're used to being in control. They're used to understanding how they set the rules of the game. In a courtroom, you're not in control. You're not in control of the court, the judge, the situation, the jury, the other side, the facts. It's all going to come out and unfold around you. You can only control yourself. So you have to understand that power dynamic. And in a courtroom, there's one boss, and that's the judge. And believe me, I can tell you that Jack Weinstein, that federal district court judge that I had the opportunity to clerk for, he knew exactly who was in control in that courtroom. And believe me, so did everybody else. I have watched him dress down the other side for looking at us. So as clerks, we would sit on one side of the table. Often the judge, especially a judge as confident as him, wouldn't sit up on the bench. He'd sit down at the big table in front and he'd put the parties on the other side. We would be sitting next to him. And there was one attorney who was quite refined, had a beautiful jacket, cufflinks, very put together. And he was presenting to everybody. And he really made a point of, as he was making his case, talking to all of us clerks, to the point where even as a clerk, I was uncomfortable. He was putting a lot of attention on me. I can tell you the judge didn't hear a word he said because at some point Jack said, "Hey, me, I'm the judge. Talk to me. And I was stunned and shocked, but it was the best example of who's the boss in the courtroom. It's not the clerks. It's not even the jury. It's the judge. So understand the power dynamic in a courtroom, and don't think because you're the boss out there in the world, you run big companies and you have a lot of money, that somehow that translates to you being the boss in the courtroom. You are not the boss in the courtroom. The judge is the boss in the courtroom. And again, if you don't understand that, you're going to do things that make the judge not like you. You're going to roll your eyes. You're going to disrespect. You're going to pretend or seem like this isn't serious, that you're not in a situation that is, for somebody, very, very important with very real stakes. So you respecting the power structure is you respecting the system, which you have to rely on in this case. So don't make the mistake of thinking you're in control in a courtroom. You're just not. There's also a whole set of rules that unless you're a trial attorney and do this every single day, you're just not going to understand. Rules of civil procedure, rules of evidence, rules of how things work. And so while things might seem unfair or disorganized to you, they're actually going through a system. They're actually following an order. And so you have to make sure that your side, your attorney, and you understand what that is and put the right things in the right place at the right time. The other thing to understand is that the judge has a lot of options to really show you disrespect if you show him or her disrespect. Summary judgment motions or hearings about introduction of evidence or other things can quickly turn the case completely in either direction. And in some cases, end the case immediately. So a summary judgment is basically saying, hey, before we go to trial, there's no reason to go to trial, judge. Just make a judgment based on these facts. And if in the very first hearing, the judge got the impression that you're really authentic, and then they're reading the brief and they see that the facts are against the other side, you're very likely to get that summary judgment and the case is gone. Because frankly, the judge doesn't need another case on the docket. It used to be that courtrooms were, frankly, not as crowded. I mean, we didn't sue as much. We didn't have as many cases going to trial. Today, we just have an overabundance of cases and attorneys, and the docket is full, and the judges are overworked and burdened, and frankly, they're tired of it. And if they can get a case off in a summary judgment, they will. And you can make this work for you, or you can make this work against you. The other side can also get a summary judgment against you. So it's very important, and you understanding that the judge has tools to turn the tide on the case in a certain way, and then say, hey, I'm gonna make this ruling that makes it really clear that you're probably gonna lose. Now, you guys go back to the table, start negotiating. I don't want to see you back in my courtroom again. I can't even tell you how many times I've heard clients tell me that's exactly what the judge said. And I have seen it firsthand in the courtroom myself. So believe me, there are tools and tactics that the judge can use to make the case go the way that they want it to go. So understand that. Understand that this game is not your playing field. You don't set these rules. But if you learn them, you can play by them. Courtroom rewards discipline, calmness, groundedness, and authenticity. It punishes emotion and poor behavior and disrespect and somehow believing that you're right is enough, because it's not. You must stay calm and clear and let the process work for you, not against you. So if you want to understand how you having your assets protected influences and affects this entire process from complaint to collection, then I would strongly recommend that you book an asset protection analysis with my office. There's a link below. We'll go over your facts, your assets. We'll give you a clear idea of what's already protected. We'll tell you what can be done for assets that are not protected and help you understand your situation so that you can make a clear choice about what's best for you. You can book that online. There's a link below in the description. And remember, it's your money. Act like it.